Mr President.
The Leader of the Opposition.
Mr President, I lead for the Labor opposition on the Justice Legislation Amendment Bill number 2. The opposition does not oppose the bill. The bill's object is to amend various and varied pieces of legislation relating to courts and crime and related matters. Amendments are proposed to the Criminal Procedure Act, the Law Enforcement Powers and Responsibilities Act, the Mental Health Forensic Provisions Act, the Crime Sentencing Procedures Amendment, Sentencing Options Act.
Would members please take their conversations outside?
The Terrorism High Risk Offenders Act, the Government Information Public Access Act, the Crimes Act, the Crime Sentencing Procedure Act, the Children's Criminal Proceedings Act, the Succession Act, the Supreme Court Act, the Criminal Assets Recovery Act, the Court Suppression and Non-Publication Orders Act, the Crimes, Domestic and Personal Violence Act, the Guardianship Act, the Powers of Attorney Act and the Young Offenders Act. The amendments to these 17 pieces of legislation are quite diverse. In addition to amendments to these 17 acts, which are all contained in Schedule 1, an additional Schedule 2 provides consequential and revision amendments in the nature of statute law revision to 23 other pieces of legislation, including some that are amended pursuant to Schedule 1. Schedule 1.3 amends the Court Suppression and Non-Publication Orders Act. Section 8(1)(d) of that Act currently provides that a court may make a suppression order if it is necessary to avoid causing undue distress or embarrassment to a party or to a witness in criminal proceedings involving an offence of a sexual nature, including an act of indecency. This provision caused the government some considerable embarrassment in November last year in a district court case at Dubbo. The identity of the defendant was suppressed in an historic sex abuse case, even though the complainant was perfectly happy to have her identity revealed. Unsurprisingly, this history wasn't acknowledged in the second reading speech, although it's fairly obvious that was the genesis for this amendment. At the time, the opposition thought that this outcome was a bit silly, although the court was undoubtedly just applying the law as it then stood. The general principle of open justice is not only a good one, but a necessary one, and should not be departed from without powerful and compelling reasons. This proposed amendment inserts a new subsection 3 which qualifies subsection 1(d) by stating there must be exceptional circumstances for a suppression or non-publication order to be issued to avoid causing undue stress or embarrassment to a defendant in criminal proceedings involving an offence of a sexual nature. Schedule 1.4 provides amendments to the definition portions of several parts of the Crimes Act. Among other things, it makes it clear that the breasts of a female person or transgender or intersex person identifying as female are private parts, whether or not the breasts are sexually developed. The necessity for this amendment is said to flow from a Court of Appeal, criminal appeal decision. The second reading speech does not identify which case that may be. I would ask that the Parliamentary Secretary, in reply, indicate the name of that case. Schedule 1.6 amends the Crimes, Domestic and Personal Violence Act so that proceedings relating to an apprehended violence order against a child are to be held in closed court, as is currently the case for proceedings in which a child is a witness or a protected person. This is one of the cases where there are very good reasons for a closed court. Schedule 1.7, Mr President, amends the aggravating, mitigating and other factors in sentencing contained in Section 21(a) of the Crimes Sentencing Procedure Act. As aggravating factors to be taken into account in sentencing, an aggravating factor to be taken into account in sentencing is if the victim's occupation is a person working at a hospital other than a health worker. Health workers are already dealt with by Clause 21(a)(2)(a). This amendment is to include persons such as security guards and support staff. Schedule 1.8 is also quite interesting. 19 of the amendments in this schedule amend the as-yet uncommenced provisions of the Crimes Sentencing Procedure Amendment Sentencing Options Act. That legislation passed Parliament last year. It's now midway through this year, and last year's legislation still has not been brought into effect by this government. The government's legislative program and its implementation is about as speedy and efficient, Mr President, as the construction of the CBD light rail project. The Labor opposition welcomed some of the 2017 provisions with some enthusiasm. We should have known, Mr President, it was just too good to be true. Could we trouble the Parliamentary Secretary in reply to indicate if it's actually proposed to commence provisions, and if so, when it might be? Will it be, for example, before the state election? We're just asking for information. It's not unreasonable. This Parliament has enacted legislation. The government has not brought it into effect by executive action. The Parliament is owed some courtesy and some explanation. This, of course, demonstrates more than tardiness by the government. It has a whiff of rank incompetence about it, requiring amendments to their own legislation within 12 months of its introduction and before it commences. You would have thought they would try to get it right at the first time, but of course it's actually a serious matter. If it wasn't so serious, it would be comical. Schedule 1.10, item 14, amends the Criminal Procedure Act relating to what it calls terrorism evidence. This evidence is designated by the prosecuting authority to be terrorism evidence. If they can apply this designation even if material has already been handed over, they can apply this designation even if material has been handed over. A legal representative can be given a copy of the material with restrictions as to how it can be seen by their client. An unrepresented defendant can obtain reasonable access to view or to listen, but not to copy the material. Item 15 in Schedule 1.10 inserts Clause 298 capital A into the Criminal Procedure Act, which provides in criminal proceedings that a person cannot seek to compel by subpoena or otherwise a victim of a sexual assault offence to reveal the identity of the victim's counsellor. Mr. President, this is an important provision. Mr. President, being a former legal practitioner like myself, you would remember the controversy that occurred in the mid to late 1990s when the protections for sexual assault counsellors' notes had a hole punched in them by a decision of the Court of Criminal Appeal, necessitating further amendment by the Parliament. That was, while not critical of the courts for applying the law as they understand it to be, nevertheless the policy outcome was undesirable and the Parliament had to patch up the legislation, and so this provision is travelling in that same direction to protect victims of sexual assault and their privacy. We welcome that. Schedule 1.13 amends the Government Information Public Access legislation by providing it to be conclusively presumed that there is an overriding public interest against disclosure of information contained in any document prepared for the purposes of the High Risk Offenders Assessment Committee. Putting a different hat on, putting things in the conclusive presumption against disclosure is a very significant step, but again, given the nature of the legislation involving high-risk offenders on this side of the House, we do not oppose that provision. Schedule 1.15 applies the Civil Procedure Act to proceedings by the local court before the Chief Industrial Magistrate, and this is achieved by amendment to the Industrial Relations Act. Now, there is no longer a Chief Industrial Magistrate's Court in New South Wales, although I understand, as a matter of practice, all persons commissioned as magistrates are commissioned as industrial magistrates. Industrial Magistrates Court performed an important role in both work health and safety prosecutions and award enforcement and underpayment cases under both state awards and agreements, federal awards and agreements. It was a very important part of the industrial relations system, but some time ago its jurisdiction was effectively folded into the Industrial Court, now abolished, now reposed in the Supreme Court. Now, I understand the reasons behind the necessity for this amendment. We certainly do not oppose it. It keeps the infrastructure of an industrial magistrates court in this state alive legally, waiting for further jurisdiction to be conferred upon it by the next Labor government elected March of next year. So we welcome this amendment also. Schedule 1.17 amends what is known as the Law Enforcement Powers and Responsibilities Act, the so-called LEPRA legislation. It removes Part 4, Division 2 and creates a new Section 23. The existing power of the police requires a person in a public place or school to submit to a search if the police officer suspects, on reasonable grounds, that the person has a dangerous implement. Now, that does not actually give the police power to search on one view. This amendment clearly does give them that power. So whether it's a clarification or a substantive change to the law, I rather suspect the latter, but again, we do not oppose this provision. 198 capital A is amended so that when a police officer gives a so-called move-on direction to a group of intoxicated persons in a public place, the police officer is not required to repeat the associated warning to each individual person in the group. This applies the existing provision about warnings to persons in a group under Part 15 of LEPRA to a warning under Section 198, subsection 6. The Supreme Court Act is also amended to take account of the decision of Morgan versus the District Court of New South Wales, 2017 square brackets New South Wales Court of Appeal 105. While mentioning amendments to the Supreme Court Act, I ask again the Parliamentary Secretary in reply to indicate what progress, if any, has been made in implementing the recommendation of the Law Reform Commission report into the Court of Appeal. Schedule 1.22 has items running to several pages amending the Terrorism High Risk Offenders Act, which passed through the Parliament again only last year. Yet again, we have the government amending its own legislation a short time after they put it to the Parliament. This is the second example in the bill before the House of this happening. It's beginning to look more like coincidence, more evidence of questionable competence or indeed incompetence by the administration of the Berejiklian government in this state. Section 60 of the Principal Act is entirely replaced. With those comments, as I indicated at the outset, we do not oppose the legislation.